All right, Tun Malanjum, welcome to NUS. Welcome to CALS Chai Chat. We're happy to have you here, finally joining us on our first live recorded podcast. And we're obviously honored to be having you as our fifth guest on this podcast. Thank you for coming.
Thank you.
You're 3 years post-retirement now, Tun. Do you miss being on the bench, and what do you miss most about being a judge?
If you say missed, I will not use the word missed. More like in a way of, it's like kind of a head and love relationship. You want to be there, but at the same time, thank you very much, should be there. But what I feel that is absent in my life post-retirement, that of course the opportunity to express the law that I feel it should be.
What have you been up to after retirement?
I became a farmer for a while.
Yeah, tell us more about that, Tun.
And the reason why is that I grew up in a village as a farming boy. I wanted to go back to my roots. And I wanted to help out the younger generations how to modernize farming and to say that you don't have to migrate to the city to survive. You can continue living in the rural areas and yet you can modernize yourself. So I set up a school, actually, farming school.
Wow.
And teach them like a modern, it's not so much of me teaching, but I do a little bit of organizations. And they will then be there they'll be instructors, to do that and so forth. But meanwhile, I was also a student of that institute. I also learned. And if you want me to tell how to grow mushrooms or how to go grape, I can do a little bit of lecture on that now. But those are very interesting, from point A to point Z. And it makes you wonder that life is not, life should be always a moving, it's a journey and not a kind of destination. It should be a journey. So those are the little lessons that I've learned after retirement. But meanwhile, I did not live low, actually. I continue reading. That's why I follow quite a lot with NUS activities and the judgment of the courts and articles and so forth. And that's how I believe that the brain must continue to function.
Maybe we can go back into your journey as a judge and talk about a few, or some key constitutional milestones in Malaysia. Native customary rights and land issues, I'm sure these are very close to your heart as a person from East Malaysia. So aside from the question of rights or land titles that are, typically very important in these cases, what are the practical on-the-ground issues that such cases usually bring up with them? And how do judges and courts navigate these practical on-the-ground issues?
Yeah, that's an interesting question. And it's very close to my heart, native customary land or land rights and so forth. Now, the first principle, being an indigenous person myself, is this, that the indigenous, or some people use it as native, but I, for one, is quite against the usage of the word native, because to me it has actually a negative connotations. You open any history book or some Western publication, you turn the pages and you see native from Borneo, and they're all wearing chawat or half dress or look very odd, It's not that we are ashamed of that, but that's a portrayal, of the group, and which I think is, with all due respect, I think is not right. It will continue to be put as if you are yet to evolve or what to develop.
Living in trees
exactly,
and all that.
Yeah, you have not reached the civilizational stage, which I think is not fair to today's world. So, but at the same time, being indigenous, I believe that we don't own the land. We don't own the land. We are part of the land. And this is the thing that I've been actually emphasizing whenever I attended international conferences on environment or land matter. I keep on telling the audience, do not consider the indigenous as land-owning group. They are not, they are part of the land. They are on the same status as the trees and all that. And that's the reason why I said that the group that you should really trust in taking care of environment are the indigenous, not guys from the NGOs and all that. And I used to get a lot of comment when I say that. But we are part of the land. So that's the emphasis on that. Now, the other thing that at times I get quite annoyed, even before, is this matters. There's a dispute on a piece of or a chunk of parcel of land, of which the indigenous had been staying there for centuries, maybe for generations. The only missing point is that they didn't apply for that piece of paper. And suddenly, somebody from outside said, "Oh, let me apply this piece of," and then they apply for the government and they get a piece of paper. And then the next day they will go to that area and tell those guys who have been there for generations, said, "Hey, you get out." As a judge before, I'm quite happy to say this. What happened? I'm quite prepared to speak about it. When I was in one station, and this thing happened, and of course the indigenous came to court, applying for injunction and so forth. So I look at the matter and I said, yes, you have a piece of paper, but I have to consider the interests of this group. And there was a lot of argument. Of course, this a new landowner has his team of high flyers lawyers, have been paid possibly in tens of thousands. And then these guys who hardly can speak even the language, and presented maybe by a young fellow who just came out from NUS or from MU, and who could hardly understand the procedure. Now, what do you want me to do? So I said, I have to look at it in the fairest possible. So I granted an injunction, and therefore the thing was stopped, and all that. And coming back to another point, I hope I'm not talking too much. The point is this judging cases being brought to court and native customary rights and all that. I think it's very important for an arbiter, a judge sitting, to be very familiar with the area of the law, not only the principle of the law, but also the psychological ideas behind it. I was reading an article. I'm not sure whether we all read the articles when Mabo, the Australian case Mabo was written. I read an article or write-up to say that the judges actually went to live with those group, the Torres Strait settlement settlers, to understand their lives. And then only they started to consider the case, because you got to know, the psyche of that group. You cannot export your own views into them. So these are things that I feel that if you want to be an arbiter to a case like that, you have to know first what it is going inside the head or inside the psyche of that group, instead of trying to, impart yours into that.
Correct.
I think this is wrong. So I've only been maintaining that you come to deciding something with indigenous land, there should be a special tribunal. It should not be brought to an ordinary civil court.
So I know as a judge on the court, you cultivated and farmed some very interesting case law, I'm sure. And since the theme of this talk is key constitutional moments, I wonder whether we can just revisit two of them at least. One is, of course, the Indira Gandhi case, and the other is Lina Joy, both of which I suppose you would articulate as being key constitutional moments in the history of Malaysian legal history. I wonder whether you can speak a little bit about the two cases, some of the reasoning behind the judgments, and what sort of impact do you think those decisions have had on social cohesion in Malaysia?
Thank you. I will start with Lina Joy. That was in 2007, I think. Never in my life that I will actually come face to face with this kind of problem, and it has a lot of religious connotations and so forth, and what they call it quite sensitive over in Malaysia especially. And it came to us, of course, from the lower court. There was a lot of hype there, but it came before us, and I don't know why in this part of the world religion become your badge, Religion should never be your badge, isn't it? Because it's something very personal. But it's said that it is one of your badges in life over this part of the world. So, being the only one non-Muslim in the panel, so of course I think the spotlight was on me. How would I think about it? But I did not get nervous about that issue. Let's look at it as purely a point of law, purely in terms of law, and look at the jurisprudence and so forth. So that was it. And I read the judgment of the lower court, and probably were talking about religious thing and Article 3 of the Federal Constitution and so forth. The country being, Islam being the official religion of the country. Therefore, it says it holds a special position, and therefore everything then must flow from there. But I had a look at it, and of course I read some article, and I've read also some judgment of Tun Malanjum prior, and it's Muslims, judges. And I thought, obviously it's very clear that that's not the way it should be looked at. And added to that, if you read the facts of Lina Joy, it is something that if you are a fair-minded person, you think that there's so much injustice done in a way that, and let me summarize the facts in a way, when she first applied to have a change of identity card particulars, there was no law yet to insist that you must state your religion, being Islam, if you are Muslim. There was no regulation there. So she applied one, it was ignored, applied second time. Then meanwhile, they changed the rules or put in a new regulation. Said, you must therefore put. But she has already applied much earlier, And then she was I don't like to use the word trick, but in a way, she was then asked again to apply for the third or fourth times. And by that time, regulation was already in. They said, now you are caught by this. Don't you think it's a bit unfair? I've already applied long before. I should be treated as where I used to be. Why is it that now you literally got me into that situation because of your own act of sitting down, sitting on my applications? Is it not? So it's not fair. That's one. Two, I said, this is a question of discretion. Why would a person, the person who actually signed it, who is actually a public officer, refusing to exercise his own discretion and dependent on somebody's advice? This literally making himself a rubber stamp of a third party who has no business of being there to begin with. I said, these are purely administrative questions. You don't exercise your discretion properly, and so the court should be able to intervene. And that's how it is, purely administrative law. We didn't even want to touch about whether this religion is high or no, nothing controversial about that. But that's the sad thing about it. When people speak of what they know, instead of they know what they're speaking about, they're two different things, isn't it?
Right.
And that's where the problem starts. That's the situation. Now, that is for Lina Joy, as for Indira Gandhi, I'm glad that Indira Gandhi came in earlier because before that, you know well that along the line, after that, they amended the constitution, is it not, whereby they put in as well the Sharia court to be at par. And on top of that, they attempted to remove judicial power of the court. In other words, they put an act there to say the constitution is amended such a way that the jurisdiction of the court is as per Act of Parliament.
That's right.
You have destroyed basically the question of separation of powers, is it not? Yeah? So that's completely wrong. If you want to do that, and then you only have the executive then running, what happened to the Westminster model of government that you proclaimed before that? So I disagreed to that, even though the wording is, first year law student will say, yeah, the wording is very clear. If you're a positivist scholar, okay, the wording is, if you're a positivist, I said, no, it cannot be right. So that was it. I said, no, you cannot remove this judicial power to that. And the importance of Indira Gandhi, of course, is to tell the world that in Malaysia, we don't like to use the word Islamic State or theocracy state or secular and so on. You don't go into those kind of statement. But the good thing about it is that the civil court continue to hold the judicial powers and not being given to somebody else who were actually put in subsequently for a certain purpose. Why would a newcomer who was just put in for a certain purpose suddenly become the king or the controlling? So it doesn't make sense, is it not? So that's how it is to that case. And I'm glad that that's done. But every time there's a new constitutional case coming up to the Federal Court, I get a little bit, not so much nervous, but excited in a way that hopefully it will not then be making a U-turn or making a right turn or left turn instead of continuing with that trajectory, of how it should be read. So those are things that keep the mind going.
So do you think Indira Gandhi remedied or addressed the missed opportunity in Lina Joy?
In a way.
You were in the dissent in Lina Joy, obviously.
Yes.
It's a 2-1 decision.
That's right. In a way, it was a missed opportunity, and that's one. And two, subsequently, Lina Joy, there was a lot of cases, even by the other judge said that the minute they see the word issue on touching on the religion, Islam, nothing to do with us, throw it to the Sharia court, without even looking deeper into that, just by label, and that's it. There is no such thing as labeling in law, is it not? It's always the substance that you will look at, not the labeling. But if you go by labeling, and you are not a lawyer, you might as well just sell a kacang putih, on the street and so forth. So you have to look at the substance or the content. That's how I look at it.
I mean, these are difficult cases, Tun, with significant socio-political impact, and naturally it would implicate social cohesion. So going back to your experience as a judge, so maybe we can go a bit more sort of practical, personal into this. How do you navigate these cases, Tun, as a judge? It's difficult.
You see, at the appellate level, and I'm sure it happens in all walks of life, even if you are in the faculty, there's such thing as no man is an island. That's a saying, is it not? We all have to live as a member of a society. We have our own members of our marble groups. When you were young, you play marbles, and you have this group. Then someone will say, I won't play marbles with you anymore, and you are left isolated. That's how it is in life. So anyway, there was me, and how do you navigate that situation? Become a little bit uneasy, isn't it? Because do you then go with the flow so that you're still in that flock, or you stand up to your conscience and your sense of justice. Regardless, I chose that. So even though that I may be isolated, it's okay. Never mind, As long as you can sleep at night and you can walk with your heads high up, I says, look, I think I did the right thing. Even if I did the wrong thing, at least that's to me that I did the right thing. So what's wrong with that? Instead of you following the flock and knowing, well, that I made a mistake, I think what to do, I just follow the group. I don't think that is the way, and especially the young people. I would say this, never give in to peer pressures. And the reason why I think a lot of problems with the young people nowadays, they give in to peer pressures. And if there's a peer pressures, then you are in trouble. You're in trouble.
So I was reading a very interesting tribute to you when you retired. I think it was called Farewell to a Trailblazing Judge. And one of the things the author spoke about was, he said, apart from your integrity and independence and so on, you also had a special concern for the poor, the marginalized, and the vulnerable. Was that correct? And are you able to speak a little bit about some of the case law that you developed around this theme?
Yeah. Coming from a village, where you have to walk for about 4 hours a day to school. When you're in primary 1, primary 2, I have to walk 4 hours a day to school just to catch a train. So I have to wake up about 4:30 in the morning, walk up and down the hill, cross rivers to the nearest railway stations, take the train, and by the time you reach school, you'll be smelly and dirty because you'll go through that jungle, And those town boys will laugh because who is this fella coming from the jungle? And that was everyday affair. And you have your first meal when you come back from school and you're looking at 4 o'clock in the evening, maybe, your first meal. So having that kind of growing up environment, I understand how it is being poor and as well as being in the rural areas. It's close to my heart. But I want to make a quick caveat here, just because of that. Therefore, all the poor people are good people and those in the town are people. No. I think that would be a wrong concept. No. Everything should be fair, right? But I understood that. So, of course, the first thing I realized when I then became a judge was that there are a lot of things that can be done to help them, But then you don't have the power yet. So when I became then the chief, there's so many people, especially in Sabah and Sarawak, who are stateless. Chief Justice Menon spoke about that yesterday evening. Who were stateless, not of their own doing, but it is because lack of economic ability to apply for documentation, and two, sheer, it's not, I don't like the word ignorance, but unawareness, they are not aware, lack of awareness, that they couldn't get it. And I tell you this, even as late as 6 years ago, I think, or 7 years ago, when I was still in service and I used to visit the rural areas, the rural folks will tell me in Sabah, you're talking about deep in the jungle, of course. You tell them, hey, why didn't you go to town to apply for your documents? No one's answer. Say, look, if we go there, we'll spend at least 1 or 2 days to travel. All our saving will be gone, right? And who is going to take care of my farm while we're away? So those are questions, And what do I get out of the document anyway? It doesn't feed me. This piece of document will not feed my family. You see the logic now. So that's the reason why. So I said to myself then, I said, well, there's a saying, is it not, that you might as well go to them and help them out. And that's why we initiated, they call it a mobile court, but in a way to help out to get them process their documentations. And that's how it started, to help them out.
I wonder if I can ask a quick follow-up on that. since you mentioned the mobile court, when you started your career as a judge, what sort of perception did you have of the judicial role? And did that change over a period of time as you moved up the court structure?
I took up the job with great reluctance. You know why? Because the money outside, so comfortable, And on top of that, life was so nice because you can do anything you like, no restraint, nobody watching you, and so forth. So why do you sacrifice that kind of easy life for this kind of hermit life in a way? But at the same time, I was thinking, if you want to contribute something to help out, then give it a chance. So I intended to stay for only a year.
Wow.
That's how it is. There's always a danger. Be careful, Sometimes you say, I want to just for a year. And then it hooks on you. And then you keep on saying, okay, let me try another year. And up 28 years, stuck to it,
27 years on the bench,
Yeah,
Tun.
and then you retired to it. So that's how it is. You can't tell, actually. But that's how it is.
So did your philosophies about judging changed over time from the first year where you were a bit reluctant to your maybe 26th, 27th year?
In a way. Let me go backward instead of forward, yeah? There is a lot of sense in having judges to stay for as long as they can, Like in US, of course, it's for life appointment. In England, I think it's about 70 or 75, I think. Some countries says, well, there should be a cut-off point in retirement. But to me, there's a lot of sense on extending the life tenure of a judge. Why? When you first join as a judge, you are a novice, literally, and you are taking the law as if you are very clinical, if I may use the word, towards the law, and even in your judgment, you become very clinical, like everything must be there. And if the case law says this, you blindly say, apply it. As you go further into the years, then you realize, even if somebody from the Privy Council or from, Supreme Court, then you look at it and says, wait, this guy right or not? You start questioning, because you have more confidence then, because of your experience, you tend to be more confident in questioning those things. And because of that, then you can do, in a way, not so much of saying a better justice, but more balance in a way. And you see things overall. Whereas compared when you are still new, you tend, as I said just now, you tend to simply follow, whatever is being said, and you don't really dare to question, if I may use the word, on those ideas or principles that being initiated. You might be wrong, but then because you are, say, I'm a junior, I just follow blindly, which I think, and that is the difference. That's the evolution of a person, junior judge, coming to a senior judge.
So I wanted to raise another issue in terms of the whole model of adjudication, especially in constitutional law cases. We've seen the South African court, we've seen the Constitutional Court of Colombia kind of depart from a traditional form of adjudication when they are dealing with constitutional issues. And I was wondering, what would be your ideal model of constitutional adjudication? How should parties relate to each other as a form of partnership, as adversaries, or is there like a third model they could think of?
We all know, as a constitutional lawyer, we all know that the Constitution actually should be treated as a living document. Is it not? It's not a historical document, but it should be treated as a living document, right? Then it should not be interpreted in the way you interpret another statute. It shouldn't be given that kind of approach, like, purposive or whatever you have, that kind of, whatever. It should not be. You should give it more liberal interpretation. And it has to be in tune with the need of the society, if you ask me. That's how it should be approached. Now, if you can do as much as possible to interpret the provision so that to be in tune with the needs of society, that's how it should be. Instead of in straitjacket and no, this is how it is. I don't think that we be a right approach to constitutional interpretation. Yeah, and that's how I look at it. And on top of that, it should be used to promote, well, if you may use social cohesion in a way that society together to put it, inclusiveness should be there as much as possible instead of using it as to divide. It shouldn't be. It shouldn't be. That's how I look being as a doing constitutional law myself before. That should be the approach.
As sort of Chief Justice, you set up a sort of de facto constitutional bench in a way on the court in Malaysia.
Mm-hmm.
Did you think that was a good way of looking at constitutional issues?
Yes. That's the reason why when I said when come to constitutional issue, it should be 9 and not 3, 5 or even 7. I said no. I said anything that's dealing with constitutional point, it should be 9. I said that's the maximum, right? Full bench, and I think that's right because then you can really get the full fledged of ideas together instead of 3 fellas and so forth.
I guess one of the issues that has come up is the discretion a Chief Justice has in terms of allocating cases and sort of bench selection and so on. So I guess this would solve that problem, right, in a way?
I hated that idea of giving power to one person and handpicking. I think that is wrong. And that's why when I took the job, the next hour after when appointed, I said, no more rubbish. I don't want that power to handpick and make them to sit. I think that is wrong. So I got a programmer, close friend of mine, said, I want you to devise a system whereby all these names are in there and let the system pick. Let the app pick the names. It's not in my hand, I've nothing to do with it. It's the system. And it's being fair. You are giving it to a person, a neutral person in a way, to pick. And hopefully it's still, I hope it's still there, being practiced when I left, but that used to be. And that's why I have no hand. And people say, why don't you just pick a fella? And then, no, I said, I have nothing to do with it. Let the system pick. And I'm glad that was accepted, and the lawyers were quite happy with that kind of a system. Said, nothing more to do with the teachers. I wanted that to put that in the legislation, but unfortunately, I didn't stay that long because I have to leave. So, but it became a kind of a practice, yeah. And that's it. Instead of, because it's not fair to handpick. Either you have a full bench,
sure,
right, or you get somebody else to pick.
So we have some questions actually, Tun, from the audience, and if we could post them to you. One here is from Jacqueline. It's very interesting. Also needing you to reflect a bit on your career. What's your proudest achievement on the court, Tun?
It's a bit hard to answer. I think I put it this way. I can never forget a case, that I decided as High Court judge. It has been with me for all these years. And this is a family case. It's a divorce case and as well as a child custody. You'll be surprised, but I can tell you here, to me, the hardest type of case in court is not constitutional law. It's not involving contract law or what? Administrative. No. To me, the hardest type of case in court is a family law. Divorce, custody. It's tough. It drains you emotionally. It really drains you emotionally, And not that I hated it, but when I see that, I said, it gave me a sleepless night, actually. Because you are, especially custody, you are determining a future of young lives. What happened to them? You make a mistake, they end up somewhere, right? So there was this case. Father, mother, baby involved. They were fighting. They agreed to divorce. Happily, they agreed to divorce. How about a child? I said. Father said, I got the means to take care of her, the lady. I will be the care. I'll take care of her. The mother, no job, housewife, unemployed, can't get it. And he has a lawyer, you know. Poor mother has no lawyer for him. Now you tell me, and you sit down there. If you are very casual, kind of very cursory on things, you just order whatever it is. You would have finished the case within what, 5 minutes? Say, okay, sure, okay. Now look at it, and I listen, both sides. Both were fighting for the child. Mother says, I may be poor, but I can take care of her. I find ways and take care. The father says, I have money. I'm rich. I got work. I can take care. I can have even my mother to take care of her. So there was a ding dong. Half a day gone. They're still arguing. So I said, I tell you what, I said. Since both of you are, the way I look at it, both of you really love the child. I think the safest way is I will make the child a ward of court. Meaning to say, I'll take her and put her in a welfare home as a ward of court. Yeah. Both got shocked. The lawyer got shocked. So, okay, I said, if you both agree, I'll make a ward of court. Mother says, if that is the decision of the court, let my ex-husband have a child. The husband says, oh, that's quite a good idea. The husband said that. The Lord said, okay. I said, this is my decision. The child goes to the mother. And then the lawyer on the side looked at me and said, yeah, but she agreed, he said. And I said, the child goes to the mother. I said, you know why? I'm asking you now. So the lawyer asked me, no. I said, have you ever heard of Solomon's wisdom? Have you ever heard of Solomon's wisdom? I know who loves the child most. It's the mother, I said, not the father. So I give it to the mother. And that's why I always remember, even today. And I think it's very important for a judge to have that kind of feeling, approach to life. I could have done it so easily. Oh, and then 5 minutes done. That would be wrong. That, to me, I feel that at least I've done something which I feel that deserving. And that's why I feel very sad when I read about Indira Gandhi's children being thrown around over that, Madam Law. I feel very sad for that because there's a child on that. I feel very, very sad that is still happening to young lives, They don't know anything about it. Why should they be made a victim of the follies of the adults?
Maybe a couple more questions to wrap up our discussion. But one here is very interesting, which I think follows up from what you've just discussed. Socioeconomic problem or legal problem? So is the plight of indigenous people a legal problem or a socioeconomic problem, Tun?
Depending on the situation, I think. It can be both, depending on what the issue is. When you say social economic problem, in a way maybe, but at the same time also because that is being created by the legal problem. Could be, which whether it's a chicken or the egg situation. But to me, if you solve the legal problem, for example, statelessness, you give them a documentation, then they can go to the hospital without paying. Do you know that if you are a stateless person, even though you are indigenous right from the rural areas, but you cannot produce your identity card, if, say, your wife gives birth, you go to the government hospital, you know how much you have to pay? At least 6,000 ringgit if you have no paper to produce. But if you have a paper, identity card and so forth, you pay $1, 1 ringgit. So you see the difference? Now, if you don't solve that problem, that becomes a socio-economic problem, is it not? So most of them sometimes are compelled to do it at home delivery, and mortality, of course, will increase if it's done at home by a village midwife, right? So these are things that is an ongoing problem, and to me, there should be actually a kind of proper database, being done to help out. That should be especially meant for the financially disadvantaged people, not necessarily in the rural areas. Can also be happening even in the urban areas, those financially disadvantaged families.
So legal issues then and socio-economic, they're not mutually exclusive,
yes,
at the end of the day,
they
very
are,
interdependent.
Exactly.
Well, that's all about the time we have, Tun, and we're really grateful for your time and having this conversation with us. So thank you for joining us on CALS Chai Chats, and hopefully we can have another conversation with you about your work as an ombudsperson for the UN Security Council. Thank you, Tun.
Thank you for having me. And
thank you
very much.